All right, we'll go ahead and go live. There I am, man. All right, so this is Chris Berry, certified financial planner, certified LL attorney at Castle Wealth Group, and we do these weekly wisdom webinars every Wednesday, unless I'm traveling or something else is going on. And today I'm at our Livonia office, satellite office. So we do these webinars where we just people submit questions ahead of time or ask them live during the webinar, and I just go ahead and answer those questions. I always start with positive focus, just something positive that happened. It was nice to have a long weekend over 4th of July, Independence Day, so that was a good time with family. And with that, let me go ahead and share my screen. So I had one question submitted ahead of time. And all right. So question here, it's kind of a sophisticated question. I was surprised someone was actually reading this. Let me blow it up here. But the question is, recently read an article on the subject of IRS ruling 2023-2. I believe I'm covered on the issue, but want your opinion on the topic. Please advise if there's any issues. Okay. So I had to go back and figure out what the heck this IRS ruling was. And what it talked about, I looked at it a while ago, but what the IRS ruling was it said that if you have an irrevocable grantor trust, and again, there's lots of different types of revocable trust, there's lots of different types of irrevocable trusts, but if you have an irrevocable grantor trust that is not included in someone's estate at death, they lose step up in basis. And so we do a lot of irrevocable grantor trusts. That's our asset protection trust. From an income tax standpoint, it's taxed just like if it's in your Social Security number. And also it's included for estate tax purposes, meaning the type of trust, the castle trust that we utilize a lot of times for asset protection, it's still part of your estate for estate taxes, which typically isn't that big of an issue. If you have more than $24 million as a married couple, 12 million as a single individual, you have estate tax issues. Those are set to drop down when the Tax Cuts and Jobs Act expires in 2026. And we do have some clients where we're working on taking advantage of some of the space now that we have during the Tax Cuts and Jobs Act. But for a majority of our clients that have asset protection trusts, which are the irrevocable grantor trusts, they're also included in their estate. So you still get step up in basis. So that private or that ruling from the IRS, that doesn't apply to a majority of the trusts that we set up, because almost every trust that we set up, unless you have an estate tax issue, it's included in your estate. It's not included for like Medicaid or asset protection, but it is included in your estate for estate taxes. And if you do have an estate tax issue, then it's a different conversation. And we might look at trust to remove it from your estate. But that's really what the IRS ruling was clearing up, is that if you do set up a complicated irrevocable grantor trust that's included for income tax purposes is a grantor trust, so it's still in your Social Security number, but for estate tax purposes, it's out of your estate. So you're kind of walking a thin line. That's what the IRS ruling was getting to, not typically the trust that we're doing. And this just sheds light on that there's lots of different types of trusts out there. There's not just a basic revocable trust. You can have irrevocable trust that protect against Medicaid. You can have irrevocable trust that protect against state taxes. It's just really coming up with what is your goal, what's the best strategy, and then picking the right tools. Okay. So hopefully that was helpful. Here's another question that just came in. And if you do have any questions, please put it in the Q&A, because this is actually the last one I have. So it might be a short one, and I don't really have a good answer for this question, but I will share it just to show that, any questions that we come in, I take a shot at. I sold a cottage in Canada. What is the best way to handle the foreign sales and tax implications? You know what? That one's outside the scope of my brilliance. I'm only licensed in Michigan and can only advise with regards to matters in the US. So I don't really have a good answer for that. What I would do if you're selling Canadian property is get with an expert on the Canada side to help you with that transaction. If you were to move the money to the US always likes that. So it's not a problem moving money into the US because now they get to tax it. If you keep it separate in Canada, you're going to want to just handle that on the Canadian side, or if you were to sell, handle it on the Canadian side, and then you move the money over to the US. The US always likes when you bring money over. So it's not going to be a tax issue there because, again, they want more money here so that they can then tax it. But as to the Canadian issues, that's outside the scope of my brilliance. So I can't help you with that. So with that, that is all the questions I have. All right, make it a great week. Take care. If you do have questions, feel free to email them over.